Greetings, most beautiful people. Now, this is Trading Brigade with Georgia Eviction Coaching Network. I am elated and I want to tell you thank you for watching. If you find value here, I hope you do share, subscribe, as the intent of this channel is to bring awareness to the people, the ones who are getting evicted by the courts, the marshals, by the misapplication of this landlord-tenant statute, as the record will reveal, if carefully researched, that only legal entities or only those acting on behalf of legal entities and legal entities can be sued, right? In relation to the Landlord Act with specificity, it says both the landlord and the tenant must be legal entities. Now, as time goes by, more of this information will be shared. And if you know someone, or even if it's yourself that's going through an eviction, don't be afraid to type in your comment box and reach out. Follow me on actual Instagram by going to Georgia Eviction Coaching Network, right? And you can follow the link inside the box below. Now, I want to take you to my screen where it is this case that I will be reading and see what information we could glean from this. Now, this case is Russell versus O'Donnell. What court is this? The Court of Appeals of Georgia. Okay? The Court of Appeals of Georgia. Now, Georgia Court of Appeals is one of the court that it's actually served as an intermediate appellate court in the state, right? And that court may certify questions to the Supreme Court. So it's like a court below the Georgia Supreme Court. Now, this case was actually heard or decided on June 10th, 1974. And this is the correct citation. Now it says, a dispossessory complaint. Now you know that a dispossessory complaint is the landlord affidavit seeking a writ of possession. A dispossessory complaint was filed in the civil court of Fulton County, which named Glynette Russell as the defendant and Ainsley Forest Apartment as plaintiff. It was alleged that the defendant had failed to pay rent and demand for possession of the premises has been made. Now, this failed to pay rent is maybe 60% of the dispossessory complaints that file in these courts are related to failure to pay rent, not even tenant at sufferance or holdover, but failure to pay rent when due. Now I continue. The defendant filed an answer and counterclaim, which I commend, right? It is always good to file an answer and a counterclaim, which set forth that Ainsley Forest Apartment was not a proper legal entity and ask the court to dismiss the proceeding. The defendant denied that demand for possession had been made and by way of counterclaim alleged breach of rental agreement and asked for $10,000 and as damages. No, the $10,000 is within the limit of the magistrate court. Okay? The case came on before the trial judge without a jury. After pointing out that in its present form, the complaint was subject to dismissal, after pointing out that in its present form, the complaint was subject to dismissal, the court, over objection, allowed the plaintiff to amend the complaint. So you are seeing that because the defendant alleged or mount a counterclaim that Ainsley Forest Apartment is not a proper legal entity. The court allowed, or they were allowed to amend the complaint. The amendment set forth that the correct name of the plaintiff was J.W. O'Donnell, DBA Ainsley Forest. This amendment was supported by the introduction of a trade name registration setting forth J.W. O'Donnell, DBA Ainsley Forest. Thereafter, the defendant renewed her previous objection and further objected that the trade name, as alleged in the amendment, was not Ainsley Forest. The trade name is not Ainsley Forest and did not comport with the trade name Ainsley Forest Apartment as set forth in the original complaint. The defendant's objections were overruled. So the magistrate court overruled those objections, and it seems they might have granted the writ of possession. But let's continue. Evidence was then presented, and the trial judge entered an order finding for the plaintiff. So the order finding for the plaintiff and against the defendant's counterclaim. Now, appeal has taken to this court. The plaintiff is the appellee, right? So he's the one responding. The defendant is the appellant. Contends the appeal should be dismissed under this case, Daniel versus Federal National Mortgage, which held that where the only relief sought was possession of real estate, that appeal must be to the appellate division of the Civil Court of Fulton County and not directly to the Supreme Court or the Court of Appeals. But that's for that case that was held. Here, however, the defendant sought to recover $10,000 by counterclaim and enumerates as error the trial judge findings against her as to such claim. Georgia, under Georgia law, 1933, page 220, right? 294. Appeal must be taken directly where the amount involved is 300 or more. This section defines amount involved as including the principal amount sued for by the defendant by set off or counterclaim. So he's within the legal parameters of the court's rule or the statute. Hence, the appeal was not subject to dismissal. Okay, the ruling. The ruling on the issue involved the motion to dismiss is dispositive of this case. Now, dispositive of this case, meaning what they're saying is the motion to dismiss is a dispositive motion. Whenever an answer or a claim is filed, most time the attorney is always motion to dismiss, which is a dispositive motion to dismiss the case. They never actually respond with a what you call a responsive pleading, a responsive motion, right? So they are saying that the ruling on the issue involved the motion to dismiss is dispositive of this case. It is well settled that a suit may be instituted in a trade name of the plaintiff if it imports a legal entity. Only if, it says if, it's a condition, right? If it imports a legal entity. I continue. It is no longer issuable that under Georgia procedure, the name of either the plaintiff or a defendant may be corrected by amendment prior to judgment, so long at least as the name by which the original designated party, so you see, it's a designation, designated party, is described, imports a person. Go check this definition out. Firm or corporation, even though it is in fact not so. I want you to go back and look this case up, okay? It is no longer issuable that under Georgia procedure, the name of either a plaintiff or defendant may be corrected by amendment prior to the judgment, so long at least as the name by which the original designated party is described imports a person of whatever class, firm, corporation, even though it is in fact not so. Now, where the real defendant has been properly served, a plaintiff has a right to amend in order to correct a misnomer in the description of the defendant contained in the complaint. A party whose name is not known may be designated by any name, and when his true name is discovered, the pleading may be amended accordingly. That is according to the Civil Practice Act, right? With regard to a plaintiff, it must be shown that the name given imports a person, firm, or corporation. Where this is not done, there is no plaintiff and no action. With regard to a plaintiff, it must be shown that the name given imports a person, firm, or a corporation. It's the same thing with regard to a defendant. With regard to a defendant, it must be shown that the given name imports a person, firm, or corporation. Where this is not done, there is no plaintiff and no action, but a mere nullity, which is subject to what is called a dismissal. I hope you comprehend that. And it might take a little while for that to be sunken into the brain. Okay? But it is my pleasure. It will be my pleasure to further allow one to comprehend as best as possible. Now, let me continue. An action cannot be maintained in a name as plaintiff, which is neither that of a natural person, a partnership, nor of such artificial person as is recognized by the law as capable of suing. And this part is very important. An action cannot be maintained in a name as a defendant. Let's just swap it out for a minute. Which is neither that of a natural person, a partnership, nor of such artificial person as is recognized by the law as capable of being suing. And I'm saying to you, my people, this is one of the fundamental concepts that we must strive to comprehend as people not acting in the capacity of performing functions of public office. If you have ever studied or been a part of lawful living community, right? Shout out to Malik and the entire crew who has led a frontier in terms of comprehension and breaking down the statute, where we are clearly recognizing that we are immune from prosecution since we are not the person defined according to the legislature's intent. And it's the same thing with the eviction. It's the same thing with the traffic ticket. It's the same thing with CPS. It's the same thing with whatever statute you are being charged under. But let's just keep this one for eviction. Okay? And I continue. An action cannot be maintained in a name as plaintiff, which is neither that of a natural person, a partnership, nor such artificial person, as is recognized by the law as capable of suing. It says, a proceeding commenced in such a name, there being no plaintiff, is not an action, but a mere nullity, and may be dismissed at any time on motion. Western Atlantic, Dalton Marble Works. I have read this case. I'll leave you to go research. I've read all of these cases. Now, where the name does not import a legal entity, but in fact it is a corporation. Such defect may be cured by an amendment alleging the corporate charter. And I'm simply saying, it is telling you clearly here that only legal entities can be sued. And it is revealing to us that there are different classes of legal entities. And if we are not a legal entity, it is an impossibility for a suit to be brought against us, since such suit would be declared or should be declared as a nullity. And according to this section, it should be dismissed at any time on motion. And this is the point that I'm coming from, my people. Now I continue. This case, Smith versus Commissioner of Glynn County. If it is that you are looking to save yourself from being evicted, it is worth reading with proper comprehension of what's called capacity. See, a lot of people like to talk about jurisdiction, but you cannot get to grade 2 in all instances without getting to grade 1. So let's talk about capacity, which is preliminary. Shout out again to my Lawful Living team, lawfulliving.com. Okay? Capacity. Now, if only legal entities can be sued, and there are several classes, we need to find out what are those class of legal entities that can be sued. And upon finding out the classes of legal entities that can be sued, then we can make a proper determination if it is that we are included as people. Okay? Let's research it. Now I continue. It is clear that the term Ainsley Forest Apartment is directly analogous to that used in Western Atlantic. That's the case up here. Dalton Marble Works. Which is, yes, Dalton Marble Works. Such name would not import a natural person, a partnership, or corporation. So this is telling you clear as day right here. The classes of legal person: natural person, partnership, or corporation. What makes you a natural person? What makes you a partnership? What makes you a corporation? Question to be answered. The amendment purporting to show that the plaintiff was J.W. O'Donnell, DBA Ainsley Forest, would not aid the action, and the trial judge erred in not dismissing the complaint on motion brought by the defendant. The action, the case should have been dismissed. What are we reading? What are we reading? We are reading from the Court of Appeals, a matter that was brought to the Court of Appeals, where the plaintiff initiated a dispossessory action. The defendant responded by filing an answer and a counterclaim and asserting allegations that the name does not import a legal entity. An amendment was made, and the amendment, according to the court's opinion, the trial judge erred in not dismissing the complaint on motion that was brought by the defendant. The judgment reversed. The amendment purporting to show that the plaintiff was J. O'Donnell, DBA Ainsley Forest, would not aid the action, and the trial judge erred in not dismissing the complaint on motion brought by the defendant. This might just sound like a simple little case that doesn't hold any weight, because one might not truly comprehend what's happening. But I am inviting you to follow, find value, let's study. I invite you to my weekly Zoom calls, as I will announce the date shortly, right? But I'm saying to you, there are 3 classes of legal entities that can be sued, or that Georgia claimed to have recognized of having legal existence. that can be sued. Natural person. It just tells you. Partnership. A corporation. Okay? And I yield for now. So I'm saying to you, the landlord and the tenant must be legal entities. And if they are legal entities, whatever class they are, I yield. It might not make a lot of sense to you now, but I trust in due time that it will. It will make sense. And I see you next as I will doing a follow-up video in relation to the Landlord and Tenant Act. Since my people who are being evicted are not making the proper argument that should be made in order to prevent one from getting evicted. For those of you who to see this video, who are watching, I am demanding that you interact, type and ask questions, share your comments, right? Share this video, and let's create a new wave of energy in responding to these dispossessory action that are being filed, because some of us are reading. Not all of us are not reading. And those who are reading, like myself, and I know others as well, are able to share this knowledge to allow our people to find the strength within them to comprehend that we were made in the image and likeness of our Creator. And accordingly, dominion was granted to man. I yield, my people. Until then, we talk again.